possible when it comes to making distributions. Okay? We want the trustee to decide when to make a distribution. We want the trustee to decide how much to distribute. We want the trustee to decide which beneficiary is going to get the money. The more discretion over distributions we can give to the trustee, the more protection you will get from this trust. And I'll give you an example. In a lot of states, if you have a trust that's irrevocable as spendthrift, it is protected from virtually all creditors by statute, with the exception of someone pursuing the trust for a child support obligation. If it's child support obligation, the fact that the trust is irrevocable as spendthrift is not enough. But in all states, if the trust is irrevocable spendthrift and completely discretionary, even for a child support obligation, it cannot be penetrated. Why? Because if the trust is completely discretionary, the beneficiary does not have a property interest in the trust. The trustee has so much discretion that maybe tomorrow the beneficiary will get some assets out of the trust. Maybe the beneficiary will get no assets out of the trust ever. All that the beneficiary has is a mere expectancy. There is no property right in this trust. And if there is nothing that the beneficiary owns, there is nothing for his creditors to take away from him. Okay? So we want trusts that are irrevocable, spendthrift, and discretionary. Now, discretionary to a lot of people in a lot of cases presents a problem. We are going to give the trustee all of the discretion over this trust. Well, maybe it's not such a smart idea. Today, this trustee that we picked is our best friend, but who knows what will happen tomorrow? Can we really rely on this person to take care of the beneficiary of the trust and keep the beneficiary's best interests at heart? Well, there are a couple of ways of dealing with that. One, you can provide for these mandatory distributions, say that every June 1st the trustee distributes $100,000 or however else you want to phrase it, but put in another provision in the trust that provides that if there is a lawsuit against the beneficiary, if there is a collection event relating to the beneficiary, then anything else in the trust notwithstanding, the trustee is forbidden from making any distributions to this beneficiary for the duration of the collection event. Okay, so it's like an overriding clause that will supersede the mandatory distribution provisions. Another way of doing that is by appointing a trust protector. Now, the concept of a trust protector has not been used that much in the United States, and it's now kind of gaining in popularity. It has existed in the British Commonwealth jurisdictions for quite a while. A trust protector is simply a third party that you bring into this trust contract, into this trust agreement, and you give this third party certain powers over the trust or over the trustee of the trust. These can be positive powers, like the ability to do something, like the protector can remove the trustee and appoint a new trustee, which is probably the most commonly used power. The protector can tell the trustee what types of investments to make, or any kinds of other things you can think of. Or the protector can be given negative powers, meaning veto powers. The trustee is mandated to make a distribution on June 1st, but the protector is given the ability to veto that distribution. So if the protector sees that the beneficiary is the subject of a lawsuit, the protector will simply tell the trustee, no, you cannot make that distribution, and the trustee has to listen. Adding the protector into the trust equation allows us to retain a lot more control over the trust and allows the trust to be a much, much, much more flexible entity. And as you know, with an irrevocable trust, even though in most states an irrevocable trust can actually be revoked, it cannot be amended. So we need to retain some sort of control, some sort of way to make changes in the trust. And using a trust protector is usually a very good way to go. There is one big obstacle to our ability to use a trust for our own asset protection. And that is the prohibition against the so-called self-settled trusts. What is a self-settled trust? The concept is simple. I set up a trust, transfer my assets to the trust, and I'm the beneficiary of the trust, meaning I set it up for my own benefit. I settled it for myself. It's a self-settled trust. In most states, in 45 approximately states, if you have a trust that is self-settled, you set it up for your own benefit, it will not offer you any protection from creditors. There are now, over the past 10 years, there are about 5 or 6 states where a self-settled trust can protect your assets. Delaware, Alaska, Nevada, Rhode Island, a couple other states where you can set up a trust for yourself, and it will be an effective way of protecting your assets from creditors. But in most states, California, New York, Florida, Texas, you cannot set up a trust for yourself. It always has to be for someone else. For a lot of clients, that is not a problem. They will set up a trust for their spouse. They will set up a trust for their kids, for their mistress, for their best friend, for their dog. There's always someone else they can set up a trust for. But sometimes you will have a client who really has no one else that they can make the beneficiary of the trust, or they may have those kids and those spouses, but they simply are reluctant to name those people as the beneficiaries of the trust. What do we do in those cases? In those cases, we will usually set up a limited liability company for the sole purpose of being a beneficiary of a trust. The client will own this limited liability company. The client will be the manager of this limited liability company, so complete ownership and complete control. And this LLC will be the beneficiary of his trust. Technically speaking, the trust is no longer self-settled because the LLC has its own juridical existence. It's a separate legal person. The client set it up, the LLC is the beneficiary. Practically speaking, as you can imagine, since the client owns the LLC, at any point in time he can get the assets back through the LLC, and he can exercise some degree of control through this beneficiary, through this LLC. There are jurisdictions that have existed for quite a while that have allowed self-settled trusts. And there are these new domestic self-settled trust jurisdictions like Alaska, Delaware, and Nevada. So the question is, can we simply set up a trust for our own benefit in either one of these domestic or one of these foreign jurisdictions? Will that work? Well, as for the domestic jurisdictions, the states that allow self-settled trusts as asset protection vehicles, obviously it works for the people who live in those specific states. But what about the rest of us who do not live in Nevada or Delaware, which is pretty much the entire country? Can we take advantage of the laws of these states? And the answer is, I don't know. Nobody knows. It has yet to be litigated in any other state. And you can make arguments in both directions. On the one hand, let's say if there's litigation in California and my assets are sitting in a Nevada trust, California has to recognize Nevada laws with respect to this trust and give Nevada full faith and credit when it comes to this litigation. On the other hand, California can argue that Nevada law that gives protection to self-settled trusts violates California public policy against giving this protection to a self-settled trust. And then California does not need to give full faith and credit to Nevada's law. Until it's litigated, it's hard to say whether these Alaska, Delaware, Nevada trusts will work for those people who live outside of those few states and who own assets, particularly real estate, in other states. There are foreign jurisdictions, and we've had these foreign jurisdictions for quite a while, that have allowed us to set up self-settled trusts and protect our own assets through these self-settled trusts. And let's skip ahead to slide number 14. So first of all, how do you form a trust in a foreign jurisdiction? It's actually very simple. A trust, again, is a contract. And like any contract, it will have a provision somewhere toward the end of the trust that will say that this trust shall be governed by the laws of blank, right? So if you live in California, it will usually say governed by the laws of California. If you live in North Carolina, it will be governed by the laws of North Carolina. Fine. But just as easily, the trust can say that it will be governed by the laws of, let's say, the Cook Islands. We'll use the Cook Islands as an example. You're simply allowed to pick your jurisdiction that easily. and you have a trust that's governed by the laws of the Cook Islands. So why is it better